Hi, everybody, and welcome to Raw Law. This is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney. And welcome, everyone. This is Raw Law. Let's get into it. I see we have a few questions already. So let me jump right into it and start answering your questions because this is what it's all about, right? This is a live show. We're here live from my office, and it's all about you, the viewer, where you could ask us your questions and we answer your questions live, and we could interact a little bit, like if you have a follow-up. But the best thing to do is if you have a case, if you need a consultation, just text me, and that is 347-566-9595. And that way we could jump on a call. And, I ask when you text me, just give me like your name, brief facts, just like one or two sentences so I can almost see it happening, right? Like if you're sitting there watching Netflix, you want to be able to see what's happening. Like, got hit in the rear, for example. That's kind of all I need. Your city, your date of incident, your injuries. For example, I have a herniation at L3, L4, or I have a broken arm that required surgery, just briefly. And then I have a sense of what your case is about. And then, we could jump on a call and we can do a deeper dive. And I actually did it today with somebody, and I think it was really helpful. He had a case out of New Jersey. I was going to do a second one, but then I got a little busy because I have this trial coming up and I'm trying to prepare, and I had some other stuff. We had a mediation today, so it got a little busy, but I'm going to make sure and do the second one tomorrow. We have a few others coming up. So let's jump into it. Let's answer some of these questions. Come Along says it's that time for the law. Virgo Vibes is here, and she says, how hard do insurance companies dispute lost wages for people who are self-employed? No work in 21 months. Lost income so far is $808,000. I have tax returns and business bank statements as proof. Right. So, as long as you have the proof, you can, prove it. It's not about how hard insurance companies dispute. There's no way for them to dispute it if you have like your taxes, for example, and they show that you're self-employed and you made that amount of money the year before you got hurt. So you just submit that, and then you want to have a trial lawyer do a direct exam of you. You could have your W-2s or your whatever tax. I guess if you're self-employed, you probably have like 1099 or however, if you have a company, however you structure it, right? And then if you need to talk about future lost earnings, you'll need an economist expert. But for something like that, I really recommend getting like a trial attorney that knows how to do that, because you probably won't be able to do that by yourself. That's very complicated, right? It's like saying, how hard is it to do a stomach surgery? Well, for the right doctor, it's not very hard, but it's not something you can do on your own. Okay. And then Malono says, defendant told police she had trouble stopping her vehicle in rainy weather, but in the deposition, she said she thought traffic was moving and sped forward to rear end me. Right, that happens a lot. People say one thing at the scene of the incident, then they say something else later. It's actually good for you because a good lawyer could take that information and then really cross-examine them, right? At trial, you could say, wait a minute. So at the scene of the accident, you said, and you told the police, right? Your memory was fresh. It just had happened seconds before, and you told the police that you tried to stop your car. You were hitting the brakes. Your foot was on the brakes. And the reason you tried to stop your car was because there was rainy weather and you didn't want your car to skid. And, because of that, you did hit the other car in the rear. But when you were deposed, you swore to tell the truth. You swore to tell nothing but the truth. But now you said that you were actually trying to speed up because you thought traffic was moving. So it's a completely different scenario, right? So which one is it? Is it A or is it B? And then it seems like, wait a minute, they're trying to cover something up. They're trying to lie. And that's very powerful. And then you're going to win. But you don't even need to get there, because look, if she rear-ended you, just file a motion for summary judgment and you'll get judgment as a matter of law. I don't think you need to get there with a rear end. If it was something else, like a lane change, a question of lights, that would be great. But for a rear end, I don't think you even need to, but absolutely, that's very powerful. Okay, and then Short Guy Car Reviews says, if an attorney thinks they'll get more money if we file suit, should we proceed with suit? He said he thinks we will get more money if we file. What do you mean, think? Why are attorneys vague? Well, it's basically like he's getting an offer for you from the insurance adjuster, right? That's a claim. A claim is nothing, right? It's basically you could make a claim like I want money. Are you going to give me money? Sure, I'll give you $2,500. I want more. No. What are you going to do, right? Please? No, right? There's no way to make them pay because it's just a claim. A claim is nothing, right? It's just like you're claiming you want money, you're asking them for money, but you want them to pay you more, right? You don't want $2,500. So the way to get them to pay you more is to file a lawsuit because now that adjuster, that claims adjuster, is off the case. And there's a new insurance adjuster put on the case that's known as a litigation adjuster. And a litigation adjuster is superior to a claims adjuster because they have more authority. A claims adjuster may only have authority to like 10K, whereas a litigation adjuster has authority perhaps for the whole policy if it's like 100 policy. So yeah, it is better. And the fact that he said think just probably means, I don't know, it could be the way he talks. It could be a lot of things, but it could be that he doesn't want to guarantee, right? I agree with him. You will get more money, but there's no guarantees. It's not a science. It's not mathematical. It's the practice of law. That's what they call it, the practice. You could lose. You could go to trial, get zero, right? Anything could happen. So he can't guarantee that you're going to get more, but it is probably a smart thing to do generally. So I think you probably should file suit. I don't know what your offer is, but I'm sure if you file suit, you'll end up in general, whenever you could put pressure on them, you do better. Whenever you could put them in the corner and get them to pay more, you can do better. Okay, and then Darren Proctor says federal court is going to be delayed because of the shutdown, ? Yeah, I'm not sure. I haven't really been following that whole thing with the shutdown. Possibly. Hopefully they get that resolved. And then Clipster says trip and fall California apartment complex, knee arthroscopy surgery, right knee. Doctor says we'll need a total knee replacement on both knees. What is my case worth? Yeah. So, I mean, look, if you need a total knee replacement on both knees and it's because of the trip and fall, and the trip and fall was because of an unsafe condition, I would say that's worth a lot. That could be worth easily like over $1 million, possibly over 2. It's hard for me to say, I'd have to review the whole file. It's hard to give value based on a comment, but sure, total knee is serious. I've settled total knees for like 1.3, 1.5, and that was 1. So if you have 2, it could be even double. So it could be significant. It could be very significant. Okay, and then Clipster says, trip and fall. Oh, I'm sorry, we did that one. Short Guy Review says, for lost wages, wait, let me scroll down. For lost wages, what happens if I don't show up to work for over 12 months and half the time it was doctor notes and the other half I didn't go to work on my own behalf due to pain? I got terminated as well. So yeah, I mean, basically, if the doctor agrees that you're not able to work, then you'll get money back. If you didn't go on your own, as long as the doctor still agreed that you're not able to work because of your injury. I mean, if the doctor clears you for work and says you can go to work and you just don't go because you don't want to, you can't get lost wages. You have to show that you're not able to work, then you can get the lost wages. And if you get terminated, you just have to then argue, well, I got terminated because of my injury because I wasn't able to perform my job. And then, if you're not able to find a new job, the lost wages continue. You can get future lost wages. It's basically pretty simple. It's like the reason you cannot work is because of your injury, because of your physical condition, because of your mental, condition, but it has to be because of the incident, because of the crash, whatever it was that happened, right? Then you just get compensation for that. It's pretty straightforward. Okay, and then Dwayne says, hey, I hired the lawyer you recommended. He said he's going to file the lawsuit as soon as possible. What kind of does the rest of the process look like? Well, yeah, I mean, that's a really, really big question. I mean, it happened, the whole lawsuit process that's a long answer. It'll take like an hour to explain. But what you should do is look at my video. I have videos. I think it's called the lawsuit process. Actually, it's broken up into many parts. So the first part would be investigation, where you investigate, you get information. The next part would be filing the lawsuit, where you file the lawsuit, the defendant answers or appears. You go to the preliminary conference, you meet with the judge. The judge does a scheduling order for like deposition of the plaintiff, deposition of the defendant, document exchanges. Then once that's a whole process, right? Discovery. And during discovery, the case could settle, right? So, but when discovery is over, then you go into what's known as, in New York at least, note of issue. And then that means the case is being certified as trial ready. Now it's on the calendar. So now you're waiting for the trial. And during this time, you can do mediations, pretrial conferences. You can do, settlement as well. And if it doesn't settle, then you pick a jury and you go to trial. So that's like the short version. But, each stage has like a lot of information. So, obviously it takes like sometimes in New York to get to from the beginning when you file a lawsuit all the way to trial. It could take like 3-4 years. So, it's a big thing. But yeah, it's good if you hired a lawyer. I recommend it. Usually I only recommend really good trial lawyers. I usually do a background check on them, so you're in good hands. And then Israel says, Mr. Arkady is the best. I hope you're doing well and you have a great stream. Oh, thank you so much. I really appreciate that. And then Buckshot says, hello, Mr. Frekhtman. Hi, how are you? And Zafraz says, hey, Mr. Arkady, the defendant motion to vacate was denied. I have a pretrial December 1st. Now they want to file summary judgment. Does the denial force them to settle? So you're saying, wait, so you're saying they, meaning the defendants, want to file a summary judgment motion? And if it gets denied, whether that forces them to settle? No. Summary judgment motion just means that they are claiming that they can win as a matter of law, that there's no question of fact for a jury to determine. So basically they're saying the case is so clear they can just win automatically. So if it gets granted, the case is over, it's dismissed. If it's denied, the case is just not dismissed. It's just the same as it was before they made the motion. It doesn't force them to settle. It just, the case is still active. So then it continues on for trial. But a lot of times if they try the summary judgment, if it gets denied, they know, hey, wait a minute, now it's definitely going to go to trial. So at that point, they do make a settlement offer. It doesn't force them to settle, but it is more likely that they can try the dismissal. And if they fail and it doesn't get dismissed, well, now they know the only other option is a jury trial, right? Now the jury is going to decide the case. So now they get scared and then they start offering you more money. So that's always something you can try. And Zafraz also asks, also third deposition and extension was denied. Why do they file summary judgment when their insured was negligent and the video justifies that? Well, there's a few reasons. First of all, you got to understand the way it all works, right? The insurance company wants to pay as little as possible, right? And they want to do it as quickly as possible. But the defense lawyer is who they hire to defend the case. But the defense lawyer's interests are not exactly aligned with the insurance company's interest because the defense lawyer is a law firm, right? If they're not in-house counsel, they're a separate law firm. They want to get business from the insurance company, but they also want to bill by the hour to make money. So one of the ways they can bill is to say, hey, I can get the whole case dismissed, even if there's a video and, they're completely at fault. And then when they make a motion, they say, well, I spent, 100 hours making this motion. I had $500 an hour. So I want all this money, right? And then the insurance company pays them all this money. Now they've made a lot of money. And so they're happy, right? But then if the motion gets denied, they'll say, well, a lot of these motions will get denied, and then so basically that's why they do it. That's one of the reasons. The other reason they do it is because if it does get granted, sometimes it gets granted on a technicality. Maybe your lawyer forgets to oppose it. Now it goes in unopposed and it gets granted. Well, now they're going to be a hero. I got your case dismissed, right? Now they're going to get more business from the insurance company. So you got to understand, like, it's like sometimes people call it the triangle of promise. Like the three, there's like the insurance company, there's the insured who's the policyholder, and then there's also the defense attorney. It's like a triangle, and they all have different interests. The policyholder probably just wants the case resolved. He just wants protection. The insurance company wants to save their money but get rid of it as quickly as possible. The defense lawyer wants to bill and make money, so they're more interested in keeping it alive and delaying it. So they all have like different interests. So, but I mean, I don't know why it's kind of weird. They're making a summary judgment motion on a case where they have a video and they're completely at fault. That's kind of probably a billing thing, I would say. I don't know why else they would do that. Okay, and then Everett says, hi, Arkady, you're doing a great job. Thanks. I have a question. Okay, let me go down and read his question because somebody else had a comment in between. Okay, here it is. I have a question. Let me go. My scrolling isn't working so great today. It's like jumping around. Oh, here it is. I have a question. I'm scheduled for Settle conference in November. Can you explain the benefits of that? Or is there any benefit in having a settled conference? Well, yeah, the benefit is the case could settle. It's a conference. Basically, you show up, they ask you how much you want. You say, I want $1 million. They say, okay, we don't have it. We have 300,000. And you talk turkey. And just like a mediation, maybe it'll settle for like 500, right? So then it's settled. Then you get your money. It's guaranteed. So that's the benefit. If it doesn't settle, no harm, no foul. You just continue on. The next thing, the pre-trial, the trial. So it's like a step in the process, right? It's a step on the timeline. If it doesn't settle, you just continue on. But if it settles, then you're done. You're happy. Okay, SCB says, thank you so much for all of your advocacy and knowledge for plaintiffs. How long can the defense attorneys delay in New York City? Is there a limit in PI cases? TBI, fractured skull, post-concussion. I mean, I don't know. That's a very general question. Like, it depends why they're delaying and how they're delaying, right? A TBI case with a fractured skull, post-concussion, could be a huge case. I wouldn't delay that. I would really prosecute it. It also depends. You see, it's not only depends on the defense lawyer. It also depends on how the plaintiff's lawyer is prosecuting it. Because if the plaintiff's attorney that's handling the case is allowing them to delay, then they're going to keep delaying, right? You could delay. I've seen people call me. Sometimes they have cases from like 2002 and they're still going on. It's like insane. You could delay for 20 years. But if you know how to do it the right way, like, for example, if you have a court order and it gives you a deposition and they don't go, you have to make a motion and then say, look, I want the strike their answer. Now, the judge is not going to strike their answer on the first motion. That means like dismiss the defense. They're not going to do that, but they're going to say, they're going to give you an order of preclusion, like produce the defendant on or before, let's say, 60 days from today. And if you don't, well, now you're precluded. You can't testify. They're going to go crazy. They're going to produce him now. There's no way they're going to adjourn it again. But if you don't make that motion, they can adjourn it a second time, a third time. And these adjournments are crazy. They could adjourn it for each time they could adjourn it for 6 months. That's just one example. They could delay in other ways, but basically, so I don't know. The best thing to do is probably to text me. It's 347-566-9595. I'll also drop it in the chat, and I'm happy to do a call and discuss it with you. And then I could give you a more comprehensive, specific answer to your question. But it sounds like a good case. So yeah, you don't want to get it delayed too much. Okay. And then Virgo says, can I report my previous lawyer to the bar because she never gave me a contract to sign and ultimately refused my file? The lawsuit had wasted 16 months. I mean, it's not really going to do anything. I mean, she might get into a little bit of trouble. I don't know. Maybe she won't. You could, but it's not really going to do anything in terms of your case. It's not going to help you in any way. It doesn't really do anything. And they don't really have to, because probably they won't even get any kind of punishment because, it's just like anything, right? There's different kinds of lawyers. There's lawyers that do everything, right? They do divorces and they do real estate and they do a little personal injury and do a little immigration. So they're not going to know how to do all these things, right? So if you have a case like your case, you really need a trial lawyer that goes to trial, that has a track record of success. And now it sounds like you have somebody new that's good. So just have them run with it. And I wouldn't worry about the past. It's not going to help you. Buckshot says, in New York City, what exact requirement must there be in a loss of consortium case, especially if the husband can't go back to work in over a year? So there's no requirement. It's just basically all you have to be is married at the time of the accident, right? You have to be married. And then if you have the injury, what you do is you sue for the husband who got hurt. That's the physical injury. And then you also sue for the wife who, lost all of the things that the husband used to do for her. And now she has to do extra things for the husband. Plus, there's relations, right? Intimate relations. There's a lot of things you could sue for. It's basically one lawyer that is really good with this. Actually, that people bring her in. She's not from New York, but she's really good. And I did a webinar with her, and actually, a live workshop with her. I was actually reviewing it last week. So anyway, what she does is she says it's an injury to the marriage, which is true, right? It's an injury not just to a person, like the person who gets physically hurt, but it's an injury to the marriage because the entire marriage is now suffering because of this significant injury, especially if the husband can't go back to work for a year, right? That's a serious injury. So it's not just, it's work, it's lost income, it's intimate things, it's everything you could think of. You make a list, you talk about stories, you talk about moments in time. So also, if you need a consult for that, just text me. I'm happy to give it to you. I could give you a whole outline because actually I reviewed that workshop and I have a whole outline about everything. So it's really powerful. But a lot of lawyers, especially in New York, which a lot of lawyers are more like antiquated and they do it the old school way. For whatever reason, they don't like loss of consortium because, sometimes when you bring it up, what the defense insurance companies say is like, well, you married for better or for worse, so you just got to suck it up and deal. I mean, sure, but you didn't. It is for better or for worse, but you're not the one that caused this, right? If somebody else caused this, then they're the ones that have to pay for it. That's the whole point. So there's different types of damages. There's physical damages, like I broke my arm hurts, but there's also damage to the marriage, and you're entitled to it under the law. So if the jurors can't allow for that in their verdict, then they can't be fair jurors, because it's basically jury nullification, right? They're just saying, screw the law. I'm throwing the law in the garbage. I'm just going to do whatever I want because this is my belief in my mind. You can't do that. So you have to address it in voir dire, in jury selection, pick the right juror, and then you can be off to the races. You could do so well because you're entitled to your physical injury, you're entitled to mental suffering, right, emotional distress, and you're also entitled to the loss of consortium. So you're not entitled to like one or the other. You're entitled to all of them. So you get like your pain and suffering past, pain and suffering future, loss of consortium, of course, economic damages like future medical costs or, of course, lost wages. So imagine all those line items, and if all of them are big numbers, the total is huge. So it could really be worked up the right way. So I really love loss of consortium. In fact, I have this case right now. I'm doing November 5th, but the problem, I can't do loss of consortium because my client got married after he got hurt. He got married, I think, 2 years later. So I don't have loss of consortium, although that would be a great case for loss of consortium. But other cases, whenever I can, I try. Even one time I had a case where I think somebody else had it before me, another lawyer, and he filed it already. And he didn't put loss of consortium. So what I did was I filed a motion to amend the lawsuit, and it was beyond the statute. So I don't even know. But the judge somehow and the defense lawyer didn't care because they think they don't really care about loss of consortium. So I got it granted, even though it was like beyond the statute of limitations. So I always try to put in loss of consortium whenever I can. I really recommend it. And yeah, there's other lawyers also that agree with me. If you ever look at, I think on YouTube, you could look up, they have some loss of consortium videos I've seen. I think one lawyer did a webinar about it from like Trial by Human. Nick Rowley, he likes to do it. And this other lawyer that I was talking about, this lady lawyer from California, her name is Ibieri Sek. She's the one who teaches on it, and people bring her in just to do the loss of consortium. And it's also powerful because now, you have one lawyer doing the physical injury to the plaintiff, and you have another lawyer doing just the loss of consortium. And she's like, I represent the marriage, right? So now you have two lawyers. So it's also good, and it makes the jury more interested. No, it's really great. I definitely, and there's not really any requirement. You just prove the damages, just prove all the damages, list out everything, all the damage to the marriage, whatever it is, right? It could be a lot of different things like shopping and, just everything, right? Okay, and then Devin says, in your opinion, if I'm making a passing attempt on a freeway going 61 to 62 miles per hour in a speed zone of 60, what, if any, fault would be mine if a semi failed to yield at a stop sign trying to cross the road? No, I mean, why would it be your fault if they fail to yield at a stop sign and you're going like 1 mile over the limit? I mean, that's 1 mile over, 1 mile under. That's like negligible. So I don't think so. I think that's their fault. That's pretty clear cut. Okay, and then Casey says, I did my deposition last week. I'm scheduled December 13th for mediation. Do you think it will settle? It's been 2 years. Well, I couldn't really say, right? Because you're not giving me any information. It's just like saying, I have a case. Do you think it will settle? I mean, it could, but I mean, the fact that you had it last week is good, right? Because you're already at the deposition stage. So it's not like you're just filing the lawsuit. So yeah, it's possible to settle if you have it December 13th. It is the end of the year. And I've said before that the end of the year is kind of like a settlement season when insurance companies do like to settle cases, because they write it off their taxes. So it's like a good time. So don't you have that going for you? The case is at the right stage to settle. They've agreed to a mediation. So obviously they have some money for you. I don't know if your lawyer asked them for a good faith offer before going to mediation. I always do that. I always say, give me a good faith offer. Because if I know I want, like, for example, 100,000, I'll say, give me a good faith offer. If they give me a nice offer, like, 60, 70, okay, I'll go to mediation because maybe I could settle it for 80, 90. But if I ask for like 100 and their offer is like, 2,500, I'm not even going to waste my time with mediation because we're so far apart, So it just depends on all those factors, your injuries, your liability. And that's usually what determines, how much you want. That usually determines if it will settle. But the fact that they're agreeing in mediation means that they have some money already, right? They're not going to come to mediation, pay a judge, sit there for hours just to have zero. Then why are we here, right? So, you know. And Devin says, semi was tried to cross through me and the car I was attempting to pass. Well, yeah. So if you're attempting to pass a car, but you're on like a main road and they have a stop sign and they blow the stop sign right into both of you, I mean, obviously it's their fault. I don't see why you would think why it would even be a question. Is somebody telling you that it's your fault? I mean, because you're going 1 mile over? I don't think so. That's like absurd. Okay, Faith says, hi, Mr. Frekhtman. Thanks for the Q&A. I sustained a shoulder, hip, and knee, partial quad tear, injuries from a fall, slipped on food, no signs on the floor. Patrons advised workers to address before the fall. That's a good case, yeah. If the patrons advise them, as long as you get the patrons' information, get their name, their address, because now they become your notice witnesses, right? So take their deposition. Now you have it, because patrons who are there, later on, the case could take 2-3 years to get to trial. Now those patrons, who knows where they are, right? They could move to China, they could die, who knows? Now you don't have witnesses, so preserve their testimony, get their witness statement, but not just an affidavit. I would take their deposition. It just takes, you could do it in 20 minutes or 10 minutes, but now you have a transcript. Now, if they're gone somewhere, right, China, whatever, now I have their deposition. I just read it, and then that's all you need. Because now if they're going to say, I was there, I saw the food on the floor, this was like 20-30 minutes before, this plaintiff fell, and I told the workers in the restaurant or whatever it is, the store, I told them clean it up, and they didn't. Now you're beautiful. It's golden. That's what you want. You're like, that's like what everybody wants. That's like a perfect case. So now you've got it. It's locked in. You got the deposition. So now you just go in and you get your money. And you have a shoulder, hip, and knee, and a quad tear. That's serious. That could be a big case. That could be even into the millions if it's worked up the right way. I don't know where you are, but yeah, no, if you need a consult, just text me, 347-566-9595. But that should be good. But you need that deposition. Okay, let me see. Sorry, my clicker is not working so well today. And Virgo says, you recently reviewed a case of a woman who fell and got a brain injury. The offer was $140. How did defense come up with such low amounts for serious injuries? Also, $3.1 million at trial seemed low. Oh, yeah, that was the case I did. So basically, yeah, that was a case where they offered $140, and we were going to settle for $140 because another lawyer in my office thought $140 was a good number. But, it was kind of, it was a brain injury, but it was very mild. Everything was normal, but there were a few things, like a neuroquant found some things. I think we had a DTI that found some things, but the MRI was normal. Everything was normal. So it was really just post-concussion syndrome. But we had proof of the brain injury in other ways. We had family, friends, before and after witnesses. So we had to do a really deep dive. So, that's just how they came up with it, because they thought that that's what it was worth, And even a lawyer in my office who's a plaintiff's lawyer, who's actually older than me, he thought it was a good number. He was going to take it. But I told him, no, let's work this up. And then we got it all the way to 3.1. And we could have gone for more, but the client at that point wanted to take it. So it's ultimately, up to the client. But 3.1, I think, was a good number for that case, actually, because we were doing verdict searches, and a lot of the sustained verdicts were less. They were even for more serious injuries than hers, because she had no subdural hematoma. She had no brain bleed. She had a very mild, in terms of there is no mild brain injury, right? Because it's your brain, but hers was kind of mild-ish, or not as strong as the others in the verdict searches, and the others were less. They were 1.5, 2.5, something like that. So if they're getting sustained, because you have to remember, it's not just a matter of what you do in the court, but you also have to think of what's going to get sustained on appeal. Because I was telling, we had a mediation today, right? And this case was they were offering 100,000. Today they offered 200. Then they said, okay, we'll get you a number in the millions, 1.5, 1.8. And I was telling the client, look, it's not bad. If you can get 1.9, close to 2, you might think about settling it, because look, I can go to trial. Let's say we have a home run day. We get 20 million. They're not going to pay 20 million. They're just going to appeal. It's going to take us 3 years to get to trial, maybe 3 or 4 years to get to trial from today. Then it's going to take another, even if you get to 20 million, it's going to take another 3-4 years for the appeal. Now you're 8 years, into the future. And guess what the appellate division is going to do? They're going to say, 20 million, are you crazy? Just take 2. But we have 2 today. So what's the point? So you got to think of that too. And the same thing in this case, 3.1, and with brain bleeds, people are getting sustained for 2.5. So if I would have gone to trial and gotten her like 20, it would have been the same thing. But this is in the Bronx. She would have waited another 3-4 years. And then the appellate division would have said, oh, 20, that's too high. Take 3 or take 2. They could say take less than your settlement. They could say anything. So you have to know where you are, right? In California, maybe, or in another state where they keep your verdict, sure, take 30 and keep your 30, of course. But in a state like New York, where they, where they lower all the verdicts, so the judges really lower verdicts, you have to keep that in mind when you're going to trial. I think somebody once said, verdicts feed ego, but settlements feed families. That's a good quote, Verdicts feed ego, but settlements feed families. Because settlements are like you getting the money. It's actual money. Verdict is like a piece of paper. I could write 100 million on a piece of paper. Okay, who cares, right? It's just a piece of paper. So think about that. Okay, Short Guy says, how is it possible if the insurance company policy is 100K, but somehow the settlement is 300K? How does that make sense? Wouldn't that be considered a verdict if it's above the policy? Yeah, of course, that's a verdict. I mean, unless you have more, it could be 100K from one car, but then the other car might have another 250. So then you have 350 total and it sells for 300. But yeah, you can't really settle. Why would they settle for more than the policy? Unless the policy was like somehow deemed open. I mean, there's a lot of different possibilities. It's hard to say. Okay, and then Faith says, been in PT since January of 2025, no recovery. The lawyer during consult said surgeries produce higher payouts. So far, no surgery, but the doctors will assess after the 3rd round of PT. Is my case hopeless? No, didn't we just talk about this case? I think this is a good case. Why would it be hopeless? I mean, yeah, I mean, sure, surgeries do produce higher payouts, but don't do the surgery for a higher payout. Only do a surgery if the doctor thinks you need it and it'll help you, right? Your health comes first. Now, if the doctor says you medically need the surgery, then you could think about it. Get a second opinion, get a third opinion. If you need it, get the surgery. Don't do the surgery for the case. That's not good. And plus, they could fish that out, and then you could be considered like some kind of fraud, and then you could lose the whole case. I never recommend that. But I mean, I don't see why you would think it's hopeless. Like, you have all those injuries, right? Didn't we just do this case? It was the one with all those injuries that we talked about. It was like a quad tear, and it was a shoulder, hip, and knee. Partial quad tear is serious. That should be a good case. I mean, if you need a consult, just text me 347-566-9595. If you're not happy with maybe somebody, I don't know, right? Because there could be a lot of factors. Like, you could have the best case in the world, right? But it could be handled by a bozo, and then the bozo can't do anything because he's a bozo. He doesn't know how to handle it. So if you need a recommendation, I could give you the best like trial lawyer in your city. I don't know where you are, and then you have the best in your city. Then they'll get you maximum value. You won't have the bozo. The bozo will go home. I don't know. I'm just like saying, like, it's not the case always. It's who's handling it, right? Like, for example, if I take the same ingredients, right? I have like a nice piece of steak. I have like the whatever, good vegetables, potatoes, and I give it to the guy at McDonald's, he's going to do one thing. But if I give it to like the chef at like the best restaurant, the 3-star Michelin restaurant, like, Le Bernardin or whatever, they're going to do something different, right? They're going to do something better. So it just depends. Okay. And she says, sorry, I had to break up my question in 2 parts. Oh, no worries. Don't worry. Of course. That's no problem. I think probably you should text me 347-566-9595. I can give you a more detailed consult. But from what you're telling me, I mean, I don't see any issues with this case. You've been in physical therapy since January. It's already October, so 10 months. It's obviously a serious case. I mean, you're not going to get a recovery. Why would you get a recovery now? You're still in treatment, unless you want him to just call, that's a claim, and just get you like 10 grand. If you're looking for big money, he has to file a lawsuit and he has to, do the litigation, and then you'll get it later through the litigation. That's how the cases work. You don't get the payout right away. And the fact that, if the doctors think that you might need the surgery, well, like I said, if you need it and you end up having it because of a medical necessity, then it's going to make the case bigger. But you don't need, even if you don't have the surgery, it's a good case because you already have the quadricep tear. That's pretty serious. Okay, and then Jacob says, I was recently in a crash riding in a shuttle bus. My father was ejected, got a TBI, multiple fractures, also glioblastoma. Oh my God, I'm so sorry. That's a serious case. So let's see. Let me go back up. Sorry. This is hard to do, this navigation with going up and down. I had a compound fracture, tibia, fibula, lacerations to the right arm, multiple surgeries for the leg. Also, my grandfather passed away on the scene. Oh my God, I'm so sorry. I'm hoping for just compensation for all my family. The accident was 3 months ago, and we got lawyers right away and started our personal injury claim process. The driver of the shuttle was found liable, hoping for good news and ample insurance coverage. Yeah, I mean, if you have like a case like that with a shuttle, they should have a lot of coverage. Just find out, have your lawyer tell you how much there is, and have them file a lawsuit on something like that right away. Make sure they're a trial lawyer. If you need a consultation or to like vet them, you can text me. I can go to verdict search. If you tell me the name of the lawyer, I could search and I could email you privately, confidentially. They won't know like, all their past results in court, their settlements, their verdicts, if they've gone to trial. So, sometimes people say they go to trial, but they don't. Sometimes people say they got like 10 million, but then you go and you do their verdict search and they got like 2,000. It's not good. It's like one guy was like 0, 4,000, 0. I was like, oh my God, what the hell is this? So, you never know until it's like trust but verify. You never know unless you know. And if you know, you know. Okay. And then I think I missed this question from Short Guy. He says, you said it's settlement season at the end of the year. Is that why lawyers prefer to file lawsuits around this time? No, it's not lawsuits. It's settlements. So like to settle a case now, you would have had to file a lawsuit probably like 2-3 years ago. You know what I'm saying? Like basically, it's when the case is ripe for settlement, it's actually, you've had depositions already. You're on the trial calendar. But now is a good time to send settlement opportunity letters, call up adjusters. It's, settlement season. It's October, November. That's when cases settle usually because they have a write-off off their taxes. But if I just file a lawsuit now, maybe I'll be in next year's settlement season because I'm so it takes time. And Dwayne says, do most settlements go to appeal? Well, no, settlements never go to appeal. Settlement is like a contract. It's an agreement, right? You want a certain amount. They're paying you that amount, or maybe a little less, but you're agreeing to the amount. Now it's settled. You're getting the money. So it never goes to appeal. Only a verdict would go to appeal because a verdict was what a jury does, right? A jury says, hey, I think this is 20 million. And then everyone's like, are you crazy? That's too high. So they appeal. And then the judge could say, yeah, that's too high. Take, 5 or whatever. So that's an appeal. But there's no appeal of a settlement because it's like a handshake. It's like a contract. Basically, you're signing it, you're agreeing to a number, and that's what you're getting. And then Buckshot says, Mr. Frekhtman, when you find excess insurance over a starting policy limit and the plaintiff is severely injured and had multiple surgeries, does the case become more valuable? Yeah, of course. Because if you have more insurance, you can go for more money. If you didn't have the excess, right? Like for example, if the primary policy is 250, now all you could get is 250 because that's all there is. But if I find out there's 5 million excess and I have severe injuries that justify the 5 million, well, now I have 5.25, right? So of course it's more. And he says, what if the initial policy limit per se 250? Oh yeah, that's what I just said. Wow, you're good. You guessed it. We're like on the same page here. The initial policy limit is say 250, get medically and non-economically exhausted. I'm not sure what you mean. Well, that's fine because you have excess, right? So like you can exhaust, exhausted meaning they're going to pay you the 250, then you just go into the excess. Like you have 5 million or whatever it is after the 250. That's why it's important to have that. Because if you didn't have it, then all you have is the 250. Okay, and then I'm a Bean says, hey, Arkady, I'm sure you've deposed the defense lots of times. Is there a point after discovery and depositions are complete that you know whether or not you're going to be successful if a case goes to trial? Well, you never know exactly, right? Like I said, it's an art. It's not a science. So you never know. You could lose a case. You might think you're going to win a case, but you could lose. You could think you're going to get X, but you get Y. You never know. It's just like, it's jurors. It's people that are being plucked from their normal daily everyday lives and being told to go to court. They get a summons for jury duty. They show up. Sometimes it goes really well and you put the case in and you think, hey, it's a $10 million case. And then the one juror thinks, well, I don't like, whatever. Who knows what they're thinking? They could be thinking, I don't like the shirt. I don't want to give him money because I don't like your shirt. And you get like much less. Anything could happen. There's never like it's not an exact science, but yeah, like usually in terms of, you're asking in terms of the timeline, like when? Yeah, usually after depositions, already if a case is good or not, or what the issues are. And, yeah. I, I mean, once everything is done, you're on the calendar, right? So technically, when you file a note of issue, you could technically go to trial even like the next day, right? Like tomorrow, because I've already filed the note of issue, which is I've certified to the court that I'm trial ready, that everything is done and I'm ready for trial. But you don't know, right? You could be ready for trial and still have to wait another 2 years or whatever, because there's just so many cases on the calendar, right? So that's the only reason you're waiting. But you could go to trial tomorrow if there was no wait, if there was no queue or line, right? So at that point, So if that's what your question is, like when you know. And then Amiri says, I answered questions for defense and my attorneys are in the process of scheduling defense depositions. That's good. So you're moving along. And Khalif says, hi, Arkady. I just got my first offer of $45,000 from Uber, which brings my case to $60K, but my lawyer said it's too low. He asked for $200 and my 2-year mark is in December. Yeah, so just file a lawsuit, get it filed. Amiri says strong. Okay, good. No, he's in good hands. I know. Yeah, Amiri has good lawyers. I think I recommended that lawyer, right? He has those guys who just get hundreds of millions all the time. So he's going to be good. Buckshots. Everyone gets trial lawyers. They will work the case up real good. Mr. Frekhtman is known for his significant and substantial settlements and verdicts and or judgments. Oh, thank you so much. And Khalif also says, do you think from your experience we'll get a bigger payout by continuing to litigate? Yeah, I think so. I mean, of course, yeah, you got to litigate. If you don't litigate, what else is there, right? It's just a claim. If it's just a claim, it's like you pick up the phone, they can give you money, they can not give you money. There's no pressure on them. There's no reason for them. There's no stick. You know how they say carrot and the stick. There's no, I don't know. There's nothing you can do. It's just basically, you're basically dialing for dollars. You're just calling them up and saying, give me money. They could say no. And then, okay, no, please give me money. No. And then you know what I mean? There's nothing. You have to litigate. Litigation is the way to show them, hey, and not just litigate, but litigate like aggressively, quickly, not let them delay, file motions, and then, but it's a lot of work, but yeah, then you could do really well. And then show them, hey, this is worth a lot of money. Show them like like I was saying before, all the damages categories, like you have your pain and suffering, you have your past, you have your future, you have your economic damages, lost wages, you have possibly loss of consortium, you have future medical costs or future bills. Add it all in there and be like, look, I have this, I have this, I have this. All together, it's worth like, whatever, millions. So pay me. And then you have to show them. And then Faith says, thank you, Mr. Frekhtman. I fell in Pennsylvania, but live in Georgia. Don't have full use of the arm that sustained a shoulder injury. Now walk with a limp. Just discouraged by the surgery comment. We'll text you. Okay, yeah, no, if you fell in Pennsylvania, I know some excellent Pennsylvania lawyers. Maybe you have someone already that's good. I could check who you have and research them and send you all their settlements, all their verdicts. So yeah, so if you don't have use of the shoulder, that's serious. I mean, it's bad. Obviously, you want to have use of your shoulder, but it's not. I don't want to say good, but it makes the case more valuable, right? Because the whole case is based on your injury. The more injury you can prove, the more valuable is your case. So that makes your case very valuable even without the surgery. You don't really need any surgery you could have it if you medically need it, but I'm saying you don't need to have surgery to increase the value if you already have a shoulder that you can't use. I think that's enough. And then Mr. Wright says, I won my summary judgment. Is it normal for the defense to appeal it? I mean, sometimes they do. If they think they can win, then they appeal. If they think the decision was wrong. Also, is the Bronx a good venue? Yeah, the Bronx, I think, is a very good venue. It's one of the best venues probably in New York. And Jacob says, unfortunately, sorry, it keeps jumping all the way down. Unfortunately, the shuttle bus company has $2 million in insurance, which seems grossly underinsured to me and our defense team. Luckily, there are alternative routes and other parties who may be liable. Oh, that's good. Yeah, so go after everybody. And then 713 says, involved in an accident on the clock, returning to my work, location via Uber, I was struck by a tractor trailer, causing the vehicle to flip. Suffered TBI, neck, back, herniated disc, PTSD, and depression. Case value. So if you're working, but I don't know where, like what city, I'd have to get more information. The best thing to do is to text me, 347-566-9595. But yeah, if you're in an Uber, so you're just a passenger, right? You get struck by a tractor trailer. So it depends on how much that tractor trailer has. Some only have 750 or a million. Others, the bigger companies, could have like a million with like 5 million excess. So it depends on how much they have. Some have 20 million, right? And also you have a TBI. So I'd have to like know more about what type of TBI, because some TBIs could be worth like 20 million, right? So it's hard for me to say. Like if you have diffuse axonal, if you have neuroquant, diffusion tensor imaging, if you have neuroradiology, you have neuropsychology, if you have neurology, you have all the right doctors, and depending on what they found, right? Because each injury is different. Now, it's not just the medicine, it's also like, are you proving like how you were before the TBI with witnesses, like people from work, friends, family, coworkers, whoever you have in your life? And are these people or other people also talking about after the TBI, right? How you are now, how you changed. Are you having like difficulty concentrating, memory loss? Some people have like convergence insufficiency. Their eyes can't focus on one target. Other people have like, PTSD, which is very, very valuable. It just depends on who's handling it. And yeah, you said PTSD and depression. So that's huge. I mean, it just depends on who's handling the case, which lawyer you have. Like one lawyer that I know just got like 70 million. Oh no, wait, I think he got 140 million on PTSD. It just depends on like, who's handling it, how good they are. And, I can't say what it's worth. It's always going to be different. But yeah, it's a good case. Jacob says, also, I texted you. Oh man, it keeps going. I can't believe it. Every time I click, it goes down. So annoying. I don't know maybe I'm using it wrong. Jacob says, also, I texted you and I'm looking forward to talking more extensively. Oh yeah, absolutely. I'm happy to speak with you. And then Virgo says, don't all 12 jurors have to agree or else the plaintiff gets nothing? Depends on the state. Like in New York, you only have 6 jurors and 5 out of the 6 have to agree. For civil cases, usually it's like, maybe 9 out of 12, or usually it's not all 12. All 12 have to agree in criminal cases when you're, trying to put someone in prison for like a long time or get them the death penalty. That's all 12 have to agree. It has to be beyond a reasonable doubt. Civil cases, you don't have to prove beyond a reasonable doubt, which is like, a very hard standard, right? Because think about it. If you have any doubt that this person committed a crime, well, now they're out, right? A doubt creates the out. They walk out. They're not going to go to jail. They're not going to go to prison. They're going to be free. So the doubt creates the out. So it's an easy standard, but I mean, easy for the defense, hard for the prosecution. But with civil cases, it's the greater weight of the evidence. Greater weight just means like who was more persuasive. It's like the weight of a feather could make it 51 to 49, right? It's like the 51-yard line, if you like football or whatever. It's just a little bit more. It's so it's like tip the scales. People say tip the scales. You have scales. Now you tip them a little bit, like, that's all it is. So, and that applies to everything. That applies to liability, but that also applies to damages. So if I'm telling the jury, hey, this is a case worth $20 million because I have this, I have that damage, I have that, and altogether it's $20 million. I don't have to show that 20 million by 85% certainty. I just have to show it by 51%, right? The same thing. I just have to tip the scales. But like you have to discuss this in voir dire when you talk to the jury, because if you don't, guess what? They're not going to give you $20 million. They're going to think in their mind, yeah, I'll give you 20 million, but you got to prove it to me by like 85, 90%. That's what people think, but that's not the law. So these are all things that, come with experience and come with like learning. So, it's a process. Buckshot says, Mr. Frekhtman, for Queens County, would you come here to do a trial, or do you have someone else in your firm who particularly takes Queens County cases? Oh, you mean Queens, New York? Yeah, I could do trials there. Of course. I do all of New York. I do everything. I do like Bronx, Queens, Brooklyn, Manhattan. If it's a good case, just text me. I'll help you if you need help. 347-566-9595. Yeah, I mean, I could even do trials in other places. Like I've worked on cases, like I was working on a case in Florida with another lawyer. And then basically, if the case was going to go to trial, I would come down and I would do the trial with him. The same thing in Michigan. I could go like anywhere. You can get admitted pro hac vice, which means just for that one case. And I do the same thing in New York. Like I'm working on a case here in New York, and I have other lawyers from California that are really good. Like one of them just got like a verdict for 50 million, and he's already like his partner's already pro hacked in for the discovery phase. And then if it goes to trial, he's going to pro hack in and do the trial with me here in New York. We're going to do it together. So it works both ways, I like to partner with other people. I just want to do whatever is best for the client, right? I don't really think about, if I partner with them, but I have to give them a piece of the fee. That's how other people think, right? They want to think about themselves and making money, but I'm just thinking about, I feel like you make more money by doing what's best for the client, right? After all, that's what you're here for. You're a lawyer. You're like the representative of the client. And then Kali says, lawsuit already filed back in 2024. I just treated for a while, been discharged 3 times, 3 neck disc protrusions, 1 disc bulge in the lower back, 2 MBB, and an RFA, all in lower back. Yeah, that sounds pretty serious. I mean, that's a lot of stuff. So yeah, it should be worth more money if you litigate it, if you have a good trial lawyer. And then Life with Val says, how does that work if you have 3 defendants in your lawsuit? Are you suing all 3? It's a grocery store. Yeah, you just have to know like who they are. Like one could be the store, the other one could be like the landlord, and someone else could be some other relation, or maybe the cleaning company that's cleaning. You know, it depends on. And then and then the jury could say, okay, the landlord is like 10% at fault because they weren't there, but they could have fixed the floor better. The store is mostly at fault because they were there every day. They should have inspected the floor and and fixed it. It's their floor. The cleaning company could be like 20% at fault. You know, whatever. They just have to take the 100 and they have to split it up in 3 ways. So you could be like, this one's 20, that one's 20, and then that one's 60, or however. Or they could say, this one's 50, that one's 40. Or I mean, I'm sorry, this one's 50, that one's 50, and the third one is 0 because they're not at fault at all. They could say anything, it's however, whatever proof, whatever the evidence shows. And then Amabeam says, hey, Arkady, I was referring to the liability part of the case. Thank you. The liability. Yeah, of course. Liability is just like, about who's at fault and proving the liability. So. And then DB says, my case is at the finish line. My lawyer has filed for summary judgment, and the motion date is 12/2/25. What happens in either case of mediation before or after that date? So, yeah, I mean, probably you'd want to do mediation. I mean, if you're worried about the summary judgment your lawyer filed for summary judgment. Okay, so then that's not, I thought you meant the defendant. So I was going to say, if you're worried it could get dismissed, maybe do the mediation earlier so you get some money. But if your lawyer filed the motion, doesn't matter. I mean, if your lawyer filed a motion, just ask your lawyer if he feels confident that he's going to win the motion, then it doesn't really matter. You could do it before and just say, look, I'm going to win this motion. It's like a rear end or whatever it is. So, just settle with me. And if he wants to wait, you could have the motion decision, and now you have summary judgment. Now you could say, well, now pay me more because I'm going to get like 9. If it's in New York, you get 9% interest, and you have a judgment. So now you've won liability. Now it's just a question of damages. So you just show them all your damages and say, look, I have pain and suffering. I have, loss of enjoyment of life, whatever you have. I have lost wages. I have, whatever your damages categories are, and, you max it out and show them this is what I'm going to get. And then they're going to pay you more money. Mediation, remember, is just a chance to settle. Sometimes they come into mediation and they just give you an offer, and they basically are telling you, we don't have more than, and they put some arbitrary number. Like today, the mediation I did, they were like, we don't have more than 2 million. We got to pay 1 point something. Why, right? Why? Just because that's what they want to do, right? It's like, okay. It's not unreasonable. They could have said we don't have more than 200,000. That would be like really absurd. But it's not unreasonable. It's okay. It's like 1.89 is a lot of money. But I'm just saying, but if I go to trial, you can get more. So it's just don't. What I'm trying to say is don't rely too much on mediation. Don't get your hopes up in mediation, because a lot of the times that's what they want, right? They want you to go to mediation, have your hopes up. Oh, I'm going to get money. It's going to settle today. And then they lowball you. They give you unfair. They give you pennies on the dollar. And then if you don't take it, or if you, basically they want to breed discontent, be like, look at your lawyer. Hey, why did you bring me here? You brought me here. I thought we're going to get all this money, but they're only offering me like pennies on the dollar. What's going on? And they want to do that, right? They want to push all their buttons so that, basically, so I don't really like mediation that much. I mean, mediation's okay, but it's really like trials where you get the real money. Okay, and then Drakwa says, how much TBI surgery of 2-level neck fusion, right knee surgery, meniscus tears, surgery for right shoulder, labrum tear, wrist TFC surgery in a premises fall 2 years? I mean, again, the best thing to do is to text me. I can't say, I don't know where it is. I don't know exactly what you fell on. It all depends on all these factors, right? So I'd have to examine liability. But yeah, I mean, the injuries are huge. Again, remember, we just did the same question with TBI. You can't just value. Not everybody who types TBI into the chat is going to have the same value, right? Because some TBIs are very mild and they could still be worth $1 million or $2 million, but other TBIs could be major and it could be like a 30 million TBI, right? So they're all going to be different. 2-level neck fusion, I mean, that's worth a lot. That's probably worth 2-3 million right there just by itself without the TBI. And you have all these other injuries like right knee surgery that could be like 300 by itself, right? And then shoulder surgery is another 300-400 by itself. TFCC wrist, that could be another, 200 by itself. But then you add all this up, so it could be a lot, but you have to also examine if you fell in a premises and there's, no defect or there's no notice, well, then the whole case could get dismissed. You get 0, right? So there are all these factors. It's all like a confluence of factors. So, I'd have to speak with you and give you a consult. Then I could give you a more, correct answer, more complete answer. And then Nicholas says, hi, Arkady. It's the guy from Michigan that you helped find. Okay, with a law firm. Okay, that's good. Yeah. How are you? Are you liking the law firm? I hope they're helping you. And then Drak, that same guy, Drak says, how much can I get? Arkady is a very experienced lawyer. This is Dr. Joe, lawyer Arkady. My case is 3 years. Yeah, no, I'm saying this guy, Drak Wasamankwa, you should text me 347-566-9595 because I can't tell you, unless I know a little bit more. But if we do a consultation, at least then I can tell you. And then I could also research whoever you have handling it to see if they are getting amazing results, right? If they're a lawyer that's going to court and they're getting like, 7 million, whatever, 5 million, well, great, you're in good hands. But if they're not, if there's somebody who says, hey, I'm, whatever, what do people say? I'm the hammer or whatever they say, all these names. But then when they go to court, it's like 0, 0, 0, 2000. Well, then wait a minute, red flag, red flag. There's a lot of red flags, out there. So you have to like, just look into it kind of thing. I'm happy to help you. Just text me. I'll speak with you. But yeah, like I don't know how much you're going to get just from your comment. I mean, no, it's impossible. It's like, it's like they say, I don't want to be like, basically people say, what do people say that term where it depends on what you put in, right? Like anything, like AI. If I have like I put in a book to AI and I write a really nice prompt, like give me a short, like 1-page summary of this book and focus on this issue. Well, it has the whole book and it reads it and it gives me a nice answer, right? And I have a nice AI response. But if I say nothing to AI and say, summarize a book, it doesn't know what book I'm talking about. So I'm going to get like some weird answer. It's not going to be good. So that's what I'm saying. Like we need more information. You can't just say TBI because that's like saying I got an injury, but what injury, right? There's so many possibilities. And the case is 3 years old. So the case is already, moving along. Let me give you my number again. I don't know if everyone heard it. 347-566-9595. I put it in the chat. So you could text me, then I can give you the right answer. And he says, suffering from brain fog, memory headaches, treating with cognitive vestibular for 2 years. Yeah, so that's a good case. I mean, look, I think that's worth a lot. I think that could be worth, if it's built up the right way, it could be worth 10 million. I mean, it's hard for me to say, but I'd have to look at the medical records. And Israel says, so if the persuasion is there, you can get 10 million for a broken pinky toe. I mean, no, I'm not saying that. I'm saying like for serious like TBI. I mean, you could potentially, right? Anything could happen. I think one lawyer in the Bronx was good, and he went in on a bulge, just a bulge, no surgery, no injections, just a bulging disc, right? People settle those for like 10K, and he got like 5 million. So it's possible, but then it's going to get appealed, and they're going to reduce it. You're not actually. It's going to be a paper verdict. Why would you? Who cares, right? You get a piece of paper says you're owed 5 million. You're not going to actually get the money. They're just going to reduce it. So. Life with Val says, thank you. Leroy says, I have a mediation on December 9th, but the defense lawyer requested a CME on December 20th. My lawyer said it's a good thing that they agreed because if we settle at mediation, I won't have to go. What do you think? What is, I'm not sure. CME is like a case management. We don't have that CME in New York, so I'm not sure what that is, but So you're saying your lawyer said it's a good thing because if you settle, then you won't have to go. Well, yeah, I guess so. I mean, it's not really a reason to settle. Who cares if you go or you don't go? It's just a conference, right? A CME, a case management like conference. Or you're talking about like an IME, like one of those independent medical exams or defense medical exams. Either way, whatever it is, right? You go, like you just spend like 5 minutes there or whatever, an hour there, but you don't want to lose like $500,000 and settle the case short because you don't want to go to a conference. That wouldn't make any sense. Like you went to conferences before the mediation, right? And the trial is something you go to. And then Drock says, Arkady, depositions are finished. So what next? Dr. Joe Amankwa. Oh, Dr. Joe I think I remember who that is. Yeah, I think we spoke. Right. After depositions, you're going to certify the case as trial ready and then go on the calendar. Yeah. Oh, I remember your case a little bit, but I still have to know what kind of TBI because I don't know what kind. I've never looked at your medical records, but I know now what kind of premises case you're talking about at least and what. But yeah, you have somebody, right? So you should ask them what they think it's worth because you have somebody representing you. And I think I know who you have, if I remember correctly. Yeah, we spoke a few times. I think you had consultations. David says, does the client have to attend a pretrial settlement conference? No, they don't have to. The lawyer could just go. Mr. Wright says, can the plaintiff drag the case after you won summary judgment to get more money from the 9% rule? I mean, not really. Why would you want to, though? You're not going to get that much more. Like, say you get $1 million even, right? 9% is only like 90,000 off $1 million. So what are you going to drag it? Like you don't want $1 million. You're going to wait a whole year to get 90,000 extra. Like, but you're not getting the million. It doesn't make sense. I mean, even if you could, if you could delay it for like a few months, maybe, but how can you really delay it any significant amount of time? It doesn't make sense. I don't think. I mean, yeah, you could maybe drag it for like a month or a few weeks, but that's going to give you. I mean, if 90,000 is what you get in a year off $1 million, what do you get in? Like, you got to divide that by 12, right? And that's like nothing. That's like 10 grand or something, 5 grand. And remember, you only get that if you get a verdict and then they have to pay the verdict. If it's a settlement, you don't get that because it's a settlement is like an agreement, on a number and you just get that number. You could ask for a higher settlement because you have summary judgment, but they don't always pay that much more. So I wouldn't recommend delaying. I've never heard of anyone. It's creative thinking, but I've never heard of anyone actually doing that. And then defendants want to settle now. What should I expect? I mean, I don't know. You have a lawyer. Just ask your lawyer. You have somebody handling it for you. I don't know your case. Like, I don't know. Expect, what do you mean? Like, just speak to your lawyer, have them demand or have a number in your head. What do you want? If you want like 10 million, have them say 10 million and then see what they give you. If they give you 1 or 2, if you want that, take it. If you don't want it, then tell them what you want, tell them what you want. Like, I don't know. I've never handled the case. I've just consulted with you for like one time for like, 20 minutes. I can't. You should ask these questions to your lawyer. You have somebody who has all your file with all your medical records, every I dotted, every T crossed. They have all the information and they're being paid, right? So why would you be like on YouTube asking me? I mean, I don't mind helping, but it's like, it doesn't make any sense. You have somebody, right, who has the entire, it's like the answer is in the file. They have the file. They have the answer. Just ask them. And if they're not communicating with you, then maybe you have the wrong lawyer. But, I don't know. I mean, I can't tell you what to expect. How would it would be like me guessing what the defendant is going to do. Like in my case, I was trying to get like something in the 5 million range and they offered me 2, right? Or they said 1 point, not more than 2. They won't go to 2. So 1.9, like for example. So I thought that was like, okay. So that's what they did. What will they do in your case? Did I know even before my mediation was at 1 p.m. today? Did I know even at 12 that they were going to do that? No, because before they were only at 100,000. So I don't even know what they're going to do in my case. How do you know? It's whatever like I was saying, it's whatever arbitrary number they come up with because it's the adjuster, I guess. And the defense lawyer just said, we're not going to pay more than 2. So they gave us like they said, 1 point something, 1.5, 1.9. You know what I mean? How would you know that? Nobody could know that. It's all arbitrary. It doesn't make any sense. Like why 2? Why not 3? Why not 1? They could have said, I'm not going to pay more than 1, so it's just guessing. I wouldn't even worry about that. What you should do is just decide for yourself what you think it's worth together with your lawyer, and then send them a letter and say, pay me 10 million and here's why, or whatever, 5 million. Here's why, because I have this, I have this, I have this, I have economic damages. I have loss of consortium with my wife. I have past pain and suffering, future pain and suffering. Here are my photos from my life. Here's my videos. Here's who I am. I have coworkers. I have family. I have friends. Show them everything. Write them like a 20-page letter. That's what I do, right? And pay me my $5 million or whatever number by November 20th at 5 p.m. And if you don't, that's fine. But then when I go to trial, it's not going to be 5 million anymore. It's going to be like 12. And here's why: because I have lost wages, and altogether you add it up, and the total is big. And then if they don't, just stick to your guns and go to trial. Don't expect them to be fair. They always pay pennies on the dollar, the insurance companies. And I wouldn't even go to mediation unless you have a good faith offer. If you had a good faith offer before agreeing to mediation, then you would know because you already have an offer. So if they didn't give you a good faith offer, then I wouldn't even recommend going to mediation. But it's up to you. But I would definitely ask them, because they have what's called they have all the information. They have the file. I couldn't tell you because I don't have the file. I'd be guessing it's like completely, random. Okay. E. Jonathan says, I have back surgery, neck injury, and hip injury. 2 years ago, we filed with the court 2 months ago. Is electricity company at fault? My attorney tells me they are self-insured. Is that easy to settle? So you have a back surgery. That's a big injury. And you have an injury to your neck and hip, but we don't know what it is. It's just an injury. Could be anything, right? Injury is very general. Now, 2 years ago, you filed a lawsuit, and it's an electricity company is at fault, but we don't know what happened, right? We just know they're at fault. So they're self-insured. I mean, yeah, electricity companies, you could settle with them, sure. Like Con Edison. Like I settled my case against Con Edison last year. I got 2.2? That was the one with the manhole cover that flipped and the guy went up in the air. That was Con Ed. So yeah, you could settle. I mean, it sounds like a good case. Back surgery, that could be worth a lot if it's in New York or if it's somewhere else, but it has potential. And Nicholas says, tell helping me, I'm going to here, submitted my case. Can you do a verdict search and fibers for premises liability or neglect? Yeah, just let me know like what the injury is, because the verdict search is mostly based on injuries. It's not going to really be based on the type of case. You know what I mean? It's mostly based on injuries. And Mr. Wright says, what's this called? Super lawyers. Super lawyers, that's just like a directory where people pay and then, you become a super lawyer. It's like, it doesn't really mean much. It's just like one of those advertising things. And then Uncle Bando says, while in law school, did you ever have any doubts about becoming a lawyer? I mean, not really. I kind of wanted to be a lawyer even from like 8th grade. When I was in 8th grade, I took, or maybe it was 7th grade, I don't remember, like junior high school, I took a class with this professor, and he was teaching about criminal law. And I thought it was so interesting. He was talking about like the Constitution, the Bill of Rights, the Fifth Amendment, the First Amendment, freedom of speech, criminal law. I thought it was interesting. So I kind of liked it. So when I went to, college, I took some constitutional law. I took some history, political science, and then in law school, obviously law. And then I just took the bar and I became a lawyer. So I didn't really have too many doubts. I mean, I thought about other things possibly, but I just kind of, law was what really kind of, and it goes to my strength, right? Because I'm pretty good at like writing. I'm pretty good at like more, like reading, writing, maybe speaking. I'm not that great with like math or computer. I'm good at using computers, but I'm not good at like writing. I couldn't like write a program for a computer or something like that. So, so it goes into my strengths, and it's also like what I like. And I especially like being able to help people and get them justice. So I think that was a good decision. And that's Dr. Akwasami Amankwa. Okay, he says, we'll call you. Yeah, absolutely. Give me, just text me. I'm happy to help. But I would definitely ask your lawyer about that. And then E. Jonathan says, I have back surgery, neck injury, hip injury. I think we did that one, right? Okay. And then Virgo says, my lawyer said the defendant will want my childhood medical records due to my cerebral palsy. I don't remember the names of the hospitals. What if the records can't be found? Well, yeah, give them an authorization. If they can't find them, then they don't exist. They don't exist. That's it. There's not really anything you have to do. It's just that's what happens a lot of the times. Like records are only kept for 7 years. So if it's more than 7 years, they just don't exist. So that's it. That's the end of the road. And then Bagged says, if you're rear-ended at a red light, could we move to get summary judgment? Yeah, of course, right? Because you're stopped, you're at a red light, you're doing what you're supposed to be, the guy rear ends you. It's not your fault. How could a jury say it's your fault for doing what? For being stopped at a red light where you're supposed to be stopped? They're hitting a stationary object. Of course they're at fault. So you get summary judgment. It's automatic. And then Virgo says, I've never heard of anyone winning millions of dollars in my small town. It seems unrealistic here, although my damages justify the amount. Yeah, I mean, you could try if you have a good lawyer, if they're willing to do it. I mean, it just depends. Like people said that to another lawyer. Like I was working on a case where I'm working on a case with a big data study with like thousands of people. And the lawyer that works with the big data study people, he was on a podcast. Actually, I had dinner with him. I was out in a conference. It's called Jury Ball, where they teach about the thing. But I don't think I heard it in the dinner, but I heard it on a podcast. And basically he said, they told me too, he was in some small town in like Colorado, I think. And they said, you realize where you are. There's never been a verdict of this much here. And he just said, okay, so we'll just, we're doing this trial. So in 4 weeks, we'll find out. Either we'll get it or we won't get it. And then he does the trial and it's like $145 million verdict. And he's like the first one, but he hits it in some small town in Colorado. So it could be done. You just have to have the right mindset and you have to have the right experience and the right skills. If you're willing to do it, you can do it. If you think you can't do it, well, guess what? If you already think that you can't, you probably won't. So it just depends. Okay, and then Stack says, can insurance companies use your videos in court? My videos for what? Whether, I'm not sure what this says, sorry. Whether on your cases or other clients' cases. No, how could they use my videos? This is just YouTube. For what? Like, well, how would it be relevant? No, they can't use my videos. I mean, they could watch them, I guess, but they can't use them in any way. They wouldn't be admissible. They're just videos about cases. And then Nicholas says a bulging disc and also bone spurs and a fusion. Yeah, so the fusion is where you would get most of the value from. And then Aisha says, how long do drunk driving cases take? That's not really, they don't take a certain amount of time because of the type of case they are. It depends on where they are and what, who's handling them. It's not like a drunk driving case is faster than a stop sign case. You know what I mean? It just depends on who's handling it and where you are. Like I could say a Bronx case is longer than a Staten Island case because Bronx, you wait like 4 years to get to trial after you certify as trial ready. But Staten Island, you might only wait like, a year or less, like even 8 months sometimes, right? I could say that, but it's not like a drunk driving case is going to be faster or slower than a stop sign case or than a trip and fall. Or, I mean, maybe it would be a little faster than a trip and fall because it's a car accident. It's pretty simple. And it's drunk driving. So you could just kind of prove liability right away, right? But like, okay, maybe that was a bad example with the slip and fall because it would be maybe faster than a slip and fall, but it wouldn't really necessarily be faster than like a rear end. So it's more about, who's handling it and where it is. And Uncle Bando says, thank you. Oh, you're very welcome. And then Hope Humbled says, hey, Arkady, thanks for all the info and answering all the questions. I'm going on 6 years into my situation and it gets so disheartening. Sometimes it's nice to just talk to someone knowledgeable. Oh yeah, sure. No, I'm happy to help. Just text me 347-566-9595. I'm happy to do a consultation. And yeah, it's confidential. I'm happy to help. Okay, everyone. Thank you so much. Oh, we're already over an hour, so I guess I better run. But this was good. We had a lot of good questions today, and I feel like we got a lot of hopefully good answers too. But yeah, thank you so much. We'll do another one maybe later this week or next week for sure. So, and if you need any type of video, just let me know what you want to see, and I'll create a video for you so you could watch. A video about a specific topic. We have a bunch of new videos coming out. Maybe I'm going to try to add some polls to the channel too, where we have polls. So then we could ask you, and then you could tell us, like, or me, what type of video you want to see, whether it's a verdict search or a process or this or that. So yeah, please like and subscribe to our channel. Let us know what questions you have and all the very best. Okay, everyone. Bye-bye.